My name is Ashley Keaton, and I am a local entertainment law attorney. I work almost exclusively with musicians and artists. I also run the Entertainment Law Legal Assistance Project with Tulane Law School, the Tipitinas Foundation, and the Arts Council of New Orleans. We hold session every Friday and have served more than 650 artists and musicians since its inception in January 2005. We offer free, comprehensive pro bono legal services, and if you qualify, you're more than welcome to set up an appointment with me. So if there's anything that I go over today that you need further clarification on, which there should be, then feel free to call and set up an appointment. The last slide has all of my information, and there's these packets down here if you'd like some of those as well. With that, I'm going to go ahead and proceed, and feel free to ask questions. I find that when we engage in dialogue, more informal dialogue, it's more constructive to the audience, and since this is a smaller audience, I'm comfortable with doing that. I'll also take questions after the presentation, but there's a lot of this stuff I'm just going to skim over. First of all, it's boring. Second of all, you have it in front of you, and you can call me, and I'm free, so you don't have to feel constrained, and I just don't feel like talking about it, but I'll talk about the most relevant information. So with that, again, the presentation is about copyright and trademark. It's important that you know your rights and protect your work, and that is the overall theme of this workshop and of my sort of crusade right now. Please know your rights and protect them, because it's easy to do, and I'm going to show you how. And if you can't do it, I'll do it for you for free, if you qualify. Okay. This is one of those things. I'm not a tech person. I'm a lawyer. Down button. Copyright defined. Its copyright protection subsists in the following. It has to be an original work of authorship. So it has to be original, it has to be authored, and it has to be fixed in any tangible medium of expression. And this is important. This means you have to be able to look at it, touch it, see it, feel it. It can't just be floating around. And it's what we call a bundle of rights. Those are the rights that you get exclusively through Section 106 of the Copyright Act. And those are conferred immediately upon you as soon as you are finished with your work. You don't have to register your work to have these rights, but you do have to register your work to avail yourself of a lot of these rights, and we'll go into that here in a couple of seconds. The duration of the copyright is life of the author plus 70 years as of the Sonny Bono amendment to the Copyright Act, and in the case of a legal entity like Jazz Fest or the Disney company, 90 years from the creation of the work. Can everyone hear me? Okay. I have a cold, so that's why I'll sound a little nasally. Okay, the original works of authorship. It's important to understand what is copyrightable and what's not. Literary works, obviously, musical works, that's music and lyrics, it's the underlying works and the sound recording. Dramatic works, pantomimes, this is where I'd like to demonstrate, but I'm not going to because I'm on film, which is also copyrightable, and I don't want that out in the public. Graphic works, sculptures, movies, sound recordings again, and of course architectural works. Not the buildings themselves, but the drawings. And of course ideas, procedures, processes, principles that do not qualify for copyright protection. This is, I like this because it kind of reminds me of, it says evacuation. Of course, we all have that evacuation term embedded within us, whether we like it or not. This is something that I pulled off a Netherlands site, so it's not a hurricane evacuation. And of course, I don't think that any of us would really want our evacuation routes to be copyrightable, because I don't think any of us really like them. But if they were, it's not copyrightable. Ideas are not. You have to reduce it to something. Again, this is an example. I have an idea to take a photograph of a light bulb versus the actual photograph of the light bulb. His house is right on the way to Jazz Fest. Stop by. Choreography. As long as you can see the actual choreography through film or through the transcription and writing, it's also copyrightable. I'm a ballet dancer. I teach ballet, so hence the reference. You're going to get a lot of me in this, including my favorite movie, Expressions. Again, the screenplay. Screenplays are copyrightable. They're copyrightable as literary works. Motion pictures are copyrightable as works in visual art and performing arts. Characters, on the other hand, are not copyrightable. You have to reduce it to to writing. So the dude, Donnie, and Walter, these concepts, great concepts, by the way, Coen brothers, two of my favorites. The idea to have these characters, the idea to have Mickey Mouse or Tinkerbell, that's not copyrightable, but when you reduce it to screenplay or to animation, it becomes copyrightable. Whistling while you work. I know this is cheesy, but if you're singing in your backyard, and the way things are these days, everybody's got a recording studio. Hell, I have one, and I'm not even a musician. So if you're whistling while you're working in your backyard and someone hears you and they're in their backyard and their recording studio, they can go in there and take that tune that you just whistled, reduce it to sound recording, and that's theirs. It's not yours. So that idea you came up with in your backyard on your own property, that's not yours. You have to reduce it to sound recording or writing. I know I harp on that, but I do because people, they have a hard time understanding that. So this is something that I'd like to have a whole workshop in and of itself on, but the master versus the publishing, which goes, dovetails nicely into why we're here, sync up. If you're going to put your music against a film, you have to have two clearances. You have to have the clearance to use the master as well as the publishing. And typically you have to go to the publisher first, because if the master owner clears it and the publisher doesn't, you can't use it. So the owner of the master owns the actual sound recording, the digits. That's what you own, the actual tape. The owner of the publishing owns the underlying work. Now, they can be the same person or the same entity. Sometimes they are, sometimes they're not. But for instance, let's take the Meters, since it's Jazz Fest, why not? The Meters did a version of Come Together. Well, they own, or Alan Toussaint or whoever owns it, Marshall C. Horn, I don't know who owns that right now, Warner Brothers, owns the actual master, the sound recording of Come Together. But the Beatles, or their people, ABCO probably, owns the interest in the underlying work, the song itself. So if you were going to put that, if you wanted to use the sound recording of the Meters version of Come Together in a film, you'd have to clear it through the Beatles, through the owner of the Beatles publishing first, and then go through the master owner as well. And that can be very confusing. And they're both synchronization licenses. One's for the use of the master and one's for the use of the publishing. Okay, protecting your copyright. This is very important. If you mail your copyright to yourself, it does not count. It never did. It never will. It doesn't do anything. It is a waste of your 42-cent stamp. Please don't waste your money on mailing your copyright to yourself. It doesn't even hold up in court insofar as proving that you had it on this date. So again, it doesn't do anything, and it's a myth, and people argue with me about it all the time, and it drives me absolutely nuts. Please, for $35, register your copyright. It is simple. I'll do it if you don't know how to do it. And it's the one insurance policy that actually works. It's not like FEMA or the SBA or Allstate. This policy is going to work for you, at least insofar as how it's being administered now. Since the government's in charge, you never know. But right now, it's working. The advantages of registration. Again, it's public record that work is yours. You have your certificate. It's a pretty little certificate. You're eligible for statutory damages and attorney's fees. If you sue someone for infringing upon your work and they haven't received any profits, in other words, let's say someone takes your CD, burns 1,000 discs, and hands it out to their friends. Well, that's kind of crappy, right? Because that cost you a lot of money. They could have gone to Best Buy or wherever and bought the CD themselves, and instead, that they're being handed your CD for free. Well, their friend didn't make any money off of it, but that doesn't make you whole. So if you haven't registered your copyright, you can't seek what's called statutory damages, which is basically penalizing them for doing it, whether or not they got money for it or not. And again, after your copyright's registered for more than 5 years, it's considered what we call in the law prima facie evidence that it belongs to the owner. And this is why it's very hard for public domain works, which we all know are in the public domain, kind of like Indian Red. It should be in the public domain, but it's not. It's been registered with the Copyright Office for decades, and so because of that, the Indians actually have to license their own music to record it, which is crazy, but that's the way it works. registering your copyright. There are 3 different ways. There's an online system. It's very flawed and it's very frustrating, but it's better than the alternative because you actually get a serial number when you register online. You can also upload your works. You're supposed to be able to upload your works if you're a musician. It's really not possible because the way the Copyright Office has their system set up, the files are too large. It takes too long. So I'd still recommend mailing the copies of the CD, but you can still register your work online and mail your CDs later. What happens is when you register online, you'll get a serial number and you'll get a barcode. And you send your CDs off with that barcode. The Copyright Office gets it, they scan it, and bling, it goes right to your application. And that does work because every single time I've done that, which I've done it quite a bit lately, in fact, I've had 2 clients call me and say that the Copyright Office referred them to me because I do so many registrations through Sweet Home and Ella that I think they're sick of seeing my name. But it does work, and you do get assigned to an examining attorney at that time. So I would recommend, if for no other purpose, registering online because you have proof of something being somewhere and not, they can't say, well, it's in no man's land until it resurfaces, which is a quote from Civil District Court here, by the way. I'm not going to go through this in detail. These are the steps for registering online. You have to obviously submit your application, pay the $35, and then submit the copies. Like I said, you can either upload them if you can, great, but expect that to be a problem. Expect to be able to have to send them in via mail. These are just some suggestions if you're going to try to do this yourself on preparing your PC or your Mac for the registration, and I highly recommend reading this and preparing your PC because if not, you'll be like me and you'll want to throw your computer out the window 3 hours later after it's kicked you off 3 times for pop-ups and other IT jargon that I don't understand. And you're going, why can't I just, take 10 minutes to do the old forms at this point? But so once you get your PC prepared, it's a lot easier. I can say that because I've done many since then. That first time it was no fun. This goes into submitting the deposit copies. Put them in bubble tape. They have anthrax issues. This tells you how to get around that. Again, the advantages of the online filing system, it's cheaper. It's $35 instead of $45. It's faster processing time. You can check the status online, and you can. You pay it immediately. It's done. They get their money. They're happy. You're happy. It's in the system. And you can upload all of your deposits once, even if you don't upload them yourself, even if you send your deposit copies in, they'll put them into the system so you can upload them later. So just let them do the work. Okay, this is a pain. I do not recommend doing this. This online PDF file, this will make you pull your hair out. First of all, it's $10 more, but if you don't have a checking account and if you don't have a credit card, then you're kind of stuck with it. It's a PDF file that you have to complete online, and it red flags you if it thinks that you don't have all your information in, and it is not perfect, it is flawed, and it takes a lot of time, and if it takes you more than 20 or so minutes, it kicks you off. And again, if you can do the online filing system, I highly recommend that. If not, this is an alternative, and if not, you can request copyright forms from the Copyright Office. Or you can just call me because I have them all and I'll email them to you because the Copyright Office will take a year to send them to you. So if you call me, I'll just email them all over to you because I have them all scanned. This is how to fill out an old form. You can go over that on your own time. Again, I don't recommend it. Okay, registering more than one work on a single copyright application form, this is particularly important for musicians, and visual artists, photographers who have a lot of body of work. You can save money by filing all of your songs in one copyright form. The trick is to have a unique combination of authorship. If you have a lot of different authors and a lot of different songs, it's really not possible to do unless you're willing to give them credit for something they didn't do. And then you end up with the whole Lennon-McCartney-Lennon thing, and you have to hear about it 40 years later, and you don't want to be in the paper, having people talking about you like you're, petty, which is what that whole thing is. So I would recommend if you have that unique combination of authorship, if all the band members wrote, contributed in the same way, you can say, this guy did the lyrics, this guy did the arrangement, this guy did the harmony, this guy did the melody. you can do that as long as it's consistent. You can register all your songs on one form. And the way you do that is you list the title of the album as the title of the work being registered, and then all the tracks or contents titles. Same for visual art, photographers, Ashley Keaton collection number 1, and then you could send 150 photographs of your Mardi Gras Indians, which you need to talk to before you do that. But, yes.
If it's something like a publication, say a magazine, a monthly magazine.
Yes.
Do you register the issue or each individual article, or?
If it's in a magazine, there's a way to deal with that. You include on the registration the volume and the serial and what page it's on, and it's easy. And you have to send the whole magazine, or at least you used to have to send the whole magazine. I would still, just so they have it, but you can send a copy. Go ahead. Uh-huh. Uh-huh. We're going to get there. I'm not blowing you off, I promise. Okay. Okay, I just went over this. Again, this is an example, Beggar's Banquet. I take the Stones through this workshop just because I like the Stones, so it's all about me. Beggar's Banquet, these are the contents titles, the title of the work being registered. It's pretty clear. That's how you do it. Okay, author and claimant. Author and claimant are often not the same people. In particular, with respect to the music industry, because obviously the author is the songwriter, and when you sign a label deal, the label's going to want to take your sound recording, your master. They'll probably give you half of the interest in it, but they'll still want copyright ownership in it, unless you can negotiate something else. Or the publishing company will want to have at least partial credit. So you see a lot of different claimants from authors, they're distinguished, and that's handled via copyright assignment. So again, Lennon and McCartney are authors, and I will not leave out George and Ringo because Ringo's my favorite. Doesn't he look happy there? And this is the contract that broke them up. This is the contract that ultimately ruined one of the greatest bands in rock and roll history, because the copyright ownership was implicated. It's a lot of management issues also. People say Yoko broke them up. I think Greg, didn't Yoko encourage John to sign the deal? So we can kind of blame her, but this was the instrument that really broke up the Beatles. All over copyright, so it's important to get your copyright together to maintain the band. And this likely resulted in beware of ABCO. ABCO again, and they took everything from them. So George didn't look very happy there. Okay, work for hire. Guys, if you're musicians and you want to own your sound recordings, please, please, please get your session artists to sign a work for hire. You're not going to be friends forever. The band is going to break up. If someone in the room can name me one band that's been around forever that hasn't broken up, I don't know what I'll do, because I just don't have any confidence that you can. Bands break up, and when they do, there's a lot of copyright implications, and this is one of them. And even beyond the contemplating that a band breaks up, let's say you go in to record to layer some tracks on a CD that's yours. You think it's yours. It's called, Ashley Keaton Does Jazz. And I get Urban Mayfield and Kermit Ruffins and Detroit Brooks in, and I'm, guys, we're big buddies, let's jam, and it'll be my CD and we're all cool. Well, guess what? If I didn't get them to sign a work for hire, even if I paid them, when that CD makes money, surprisingly, then they're going to come back wanting to know where their money is. And guess what? They own that sound recording with you, with me, even though I paid them and they're just session artists and we're buddies. Don't do it. Use the work for hire as a receipt, if nothing else. It's a paragraph, and I've given it to you. So if you're going to pay a session artist, you might as well get them to sign off. You want it for the IRS anyway, right? Not really, but it really, I would highly encourage you to use the work for hires. If you don't, and you think you own the rights to your own work, and HBO approaches you and wants to use your work against video, which is why we're all here, the synchronization right, then you're not going to get you're not going to get, they're going to move on to the next person. I went through this with a band that I work with, and I can't mention their name, but it's not a band that you would expect to have a whole lot of work in the movie business, especially here, because it's not even New Orleans type music. And they came into Tips, and over the process of 2 years, I got their LLCs set up, I got their copyrights registered, and then we did the and the BMI and all that stuff. Then we did the dreaded clearing of the mechanical licenses through Harry Fox. And we did the work for hires, where everyone had to sign, the buddies had to sign each other's contracts, and it felt really awkward among them. But when True Blood and when Samantha Brown's Greatest Hotels or whatever, and one other Travel Channel show, and then there's what's the other HBO show? Not True Blood, but The Wire. When they approached them, they got their license because everything was clear. And had they not, they'd have just gone next, because there's always someone else out there with your type of music, and they want it to be easy for them. So if you don't do it, what incentive do they have to work with you? So you spent all this time in the studio for what? To not own work that you can do something with? And that makes no sense. So get your clearances so that you can actually market your work, and you can actually make money off of your work, so you can garner the fruits of your work, so to speak. Please. If not, then, you're shooting yourself in the foot, and it happens to everyone. If I had a dime for every single musician I've talked to who's come to me not being able to license their work because they've had a fallout with a friend that they trust, then I'd be a rich woman, okay? I wouldn't be here. Well, I would, because it's Jazz Fest, but you get the point. Must be in writing, unless you're an employee, but I'd go into that right now, except that it really doesn't fit the situation. So there's your work for hire agreement. No excuse, you have one. This will be available online. In the case of the Rolling Stones, you'll note here that ABCO is the claimant. They own the work. The Stones don't, to Beggar's Banquet, because ABCO got them to sign a work for hire. So it works both ways. Now we're going to get into derivative works. Derivative work is a work that's based upon one or more existing work. A good example of a derivative work is a sample. Sample you put into someone else's song. That new arrangement is a derivative work, and you have to get clearance from the original copyright owner. If you don't, and you're like Ludacris, then you're going to lose money every single time your song is played, because you're going to have to pay the other guy. Because if you didn't get it authorized ahead of time and you do well, then all of a sudden that's negotiable. The rights to the sample is negotiable, unlike the compulsory license rights, and your work becomes a lot more valuable, and you get into things like, oh, well, you did this maliciously. So clear your samples, clear your derivative works ahead of time. Same with photography and just about anything. Merchandise is a derivative work. If you have Monet, that's in the public domain, but you put it on a T-shirt, that's a derivative work. It's a bad example because it's in the public domain, but you get the point. Okay, again, if it's an existing copyright, then you have to have permission from the author. If it's in the public domain, all you have to have is a modicum of originality, and you can arrange. You can arrange Amazing Grace, as long as you add something to it that makes it more than what it was before. And it's just, the test is the modicum amount of originality. This is an example of a derivative work. This is a photograph of a spy boy for the Creole Wild West, and I represent them. And I also represent the Photos for Humanity, the organization who assigned their interest over to the Mardi Gras Indian tribe, as well as the author. So this is a classic case. Devin Myers is the author in this photograph. His nonprofit, Photos for Humanity, was the claimant, and then he assigned the interest in this photograph to the New Orleans Mardi Gras Indian Council, which became the new claimant, who then licensed the photograph to the Louisiana Endowment for Humanities so that they could use this as a flyer. This is when it becomes a little bit rocket science-y, but not so much. You just have to, it's very linear. A lot of people don't realize this, but Indian suits and crowns are sculptures, and another crusade of mine is to get them to register their works. And this is when photographers start throwing spitwads at me, but the plain fact of the matter is that photograph right there is a derivative work of that suit, because that's a sculpture. It's a copyrightable sculpture and 2D artwork, and as a tapestry for that matter. So that concludes the copyright segment. I want to segue into the trademark so we can get out of here. How are we doing on time? 20 to 11? Okay, cool. That'll give us a good amount of time for question and answers. Okay, trademark is a word, phrase, symbol, or design, combination thereof, which identifies and distinguishes the source of goods. Again, the trademark says, if I have Coca-Cola, this is what I'm drinking. I know I'm drinking that formula, not Pepsi. And let me tell you, if Pepsi put Coca-Cola on their Pepsi cans and I drank it, I would not be a happy camper because I hate Pepsi. Again, it identifies the source of goods. It's important. You don't want your band logo identifying some crappy artist out there. So this is when we get into your question earlier. Coca-Cola. Coca-Cola's easy because they're they go nuts over their logo. They're as bad as Disney. Don't ever infringe on Coca-Cola, please. Again, it provides notice to the public that you're consuming a product manufactured by the Coca-Cola company, not by the Pepsi company. The duration of the trademark subsists from the first use in commerce until it's no longer being used. That's a picture of the New York Stock Exchange. Sorry, I was trying to be creative, and that's as good as it got. Use in commerce, if you promote your band on your website, if you sell your music to someone out of state, I would suggest doing it out of state, because you can get an in-state trademark if you're just doing business within the state. But the in-state trademarks, I mean, they're helpful, but if you're really trying to do something with your band, then you need a federal mark because that protects you nationwide, and that also gives you the option to register for an international mark. And let's face it, everything is global now. I mean, with the internet, it's funny to me that people contemplate use in just one small market, because if you have a website, then you're doing business globally, whether you like it or not. So as soon as you promote your band online, if you even via MySpace, that works. That's use in commerce. Selling flyers, if you're getting a local mark, flyers. If your band's playing at Tipitina's and you go down Oak Street with the staple gun, that works. Doesn't work with the federal trademark, but it works with the state trademark. There are renewal requirements for both marks, but that gets into a lot of legal mumbo jumbo, and that's something that I can answer individually later. Okay, the trademark symbol versus the registered trademark symbol. A lot of people ask me about this. The TM gives notice to the public that, hey, this is a trademark, don't use it. The registered symbol says that it's registered. It tells you it's registered. Really, don't mess with my mark, because if you do, then you're going to get slapped with a lawsuit. So that's just the scarier one, is the R. That's the one you need. I'm sure he's particularly pleased that his picture's on my workshop. He looks like a happy guy. He's not going to Jazz Fest today, I bet. Again, you can register your mark with the United States Patent and Trademark Office, with the Louisiana Secretary of State, both, or any other state commercial divisions. If you're registering in more than one state, it's silly not to just go ahead and register your mark with the Patent and Trademark Office, because it's just wasting money. You get the ultimate protection by registering with the federal government. Basic registration requirements, federal requirements, again, use in interstate commerce. That means you can't just use it within Louisiana. You can ship it to your friend over in Mississippi. I'm on film. They have to buy it from you. You can't just tell your friend to order it from you. You need an invoice, and it needs to say it's gone out of state. So that's all you need. If you have a MySpace page or a website, you don't have to worry about it because that's global. In order for a mark to be registrable, it can't just be merely descriptive or generic. So it can't tell you what it does. It needs to be fanciful or arbitrary, and I swear those are their terms, not mine. But I do like fanciful. It needs to be fancy. It needs to be real fancy. So, again, you need to think about your mark ahead of time. If you want it to be protected, it's got to be fancy, real fancy, and it's got to be arbitrary. It can't mean anything, okay? And when you think about the best marks out there, they're all pretty fancy and they're all pretty arbitrary. And I've got a good example. They're not descriptive. That's pretty fancy, that Google Chrome. Now, if I looked at that, except it does kind of look like a hubcap now that I think about it, but it does. You don't look, if you didn't know anything about Google, you wouldn't look at that and think, oh, this is a faster search engine. I mean, Google, what is that? That's as fancy and arbitrary as it gets. But we all know what it means. It doesn't mean it's a search engine. I mean, it means it's a search engine, but if you're looking at it and don't have any context, social context, then it's just a word that is not in the English dictionary, which is even better because then it can't even be descriptive. Law Office of Ashley M. Keaton. That's as generic as it gets. You don't have to worry about messing with me. And, I mean, if you say that you're the Law Office of Ashley M. Keaton, God bless you and good luck. But I can't sue you for infringement. I could sue you for other things, and I would, but not for trademark infringement. Classic cases of genericide, and believe it or not, I'm sorry, I have a cold. That's also a legal term. Suicide of the trademark. That's maybe not a good band name. Hey, Philip, how you doing? It's good to see you. Okay, Kleenex and Xerox. Anytime your marks anytime people start to use your mark as a verb, I need to Xerox some copies. I need a Kleenex. I need a Kleenex so I can blow my nose. It's not a tissue anymore. It's a Kleenex. It's not a copy. It's a Xerox. These marks were so good that they've committed genericide, and they're really no longer good with the Patent and Trademark Office. They are insofar as the logos. That's what's saving them. But the block letters, no good because they're too generic. And that's a high-class problem. That's to quote someone I know. That's when you have a problem of, in the case of genericide, you've got yourself a high-class trademark problem there. It's not that you didn't do a good job. It's you did such a damn good job that it's no longer that everyone knows what it is. So at that point, what are you really worried about? But you do need to be apprised of this genericide situation. I feel like it's like an after-school program. Okay. Guys, I'm sorry. I'm hot. I mean, it's pretty bad when I'm looking forward to getting outside of Jazz Fest and sweating. I don't know if I'll sweat as much. Okay. Here's the drawbacks to the federal registration. It's more expensive. Well, go figure. Anything that the federal government is doing is going to be more expensive, except for the copyright. But it's worth it. I mean, this is one of those classic cases you get what you pay for. You get what you pay for. The state doesn't know what they're doing. They process. The U.S. Patent and Trademark Office has examining attorneys, and I would argue that they don't know what they're doing either most of the time. But they are charged with the duty to know what they're doing, and you can call them out on it, whereas the state just processes it. So not only do you have nationwide protection with the federal mark, but it's gone through a process so that if someone challenges you after it's been registered, it means something. If someone challenges you with a state trademark, it doesn't really mean a whole lot except that it's proof that you were registered in the state and you have that use in commerce. And that does serve as proof in a court of law that you were first to use it in commerce if someone challenges you. So it does have value. I'm not trying to devalue it, and I would highly recommend everyone registering their mark with the state, especially if you can't afford a federal mark, and most people can't, and that's okay because the state mark does give you some protection. But when you can afford it, if you're doing that kind of business, get the federal mark because, again, you just get a whole lot more with it. The advantages, again, constructive notice to the public, the presumption of ownership, the right to sue in federal court. If you don't have a federal mark, you can't sue in federal court. And you don't want to sue in state court because they don't know about trademarks and copyright. Well, they don't really know a whole lot about trademark and copyright in federal court unless you're in the Second and Ninth Circuit. And even there, I mean, if you get a good judge, I could tell you a story, and Greg could tell you a story about being in court in the Fifth Circuit when I literally had a judge say, well, I'm not going to help you. I don't believe in any of that art stuff. So that's in the Fifth Circuit. That's in our federal court system. I'm deterring you from registering your mark at this point. Really, register your mark, because we won, did we? We had 17, we won. That's the point, and we always do, but those are some of the hurdles that you have to jump through. If you're registering with the state, imagine if we have that in our federal court system, trademark, just if you can, do the federal. Logo versus block letters. This is a common question I get. Well, I have a logo and I want to just use my block letters. What do I do? Well, you can register both, or you could just register the block letters, because guess what? If someone uses the Star Wars logo, or if this logo were registered and someone used Star Wars in block letters, they'd still have an action, and vice versa. I would always register, if you're choosing between which one to register the block letters. First of all, it's in print. It means more. It's not attached to the logo. So it stands on its own outside the logo. But I would register the logo too in the event that someone, changes this into Spaceballs, which they did. And I don't know whether they got permission to do that. Well, that was a parody, so it didn't matter. But I'm sure Lucas threw a fit. He's as bad as Disney, and I'll show you why in just a second. I do like him. I do like Star Wars. Nice guy. Tried to hire me, but, he's a corporate whore, too. Oh, my God. Sorry. I don't think the Jesuits are going to like that. Apologize. Okay. Logo versus block letters. Again, Rolling Stone magazine. Rolling Stone has a logo, and then they're protected with their block letters as well. What if you have the same mark in different classes? Well, I think we're all familiar with Ace Hardware, especially after what we've all been through. If any of you in the room haven't been to a hardware store, then you're not human at this point. And for that matter, with the renovations we've all been undertaking, I know that I've been through. I should have bought stock in Johnson & Johnson for the Band-Aids I've used. So we've gone through the bandages too. These are two different companies. They look the same to me, but they're in two different classes. One offers hardware, one offers bandages. It's kind of mutually exclusive in that way, but there are other examples too. In the event that you have a similar trademark, it can be registered if it's in a different class, as long as there's no consumer confusion as to the source of goods. So again, if the source of goods, if the goods and services that are being offered are distinguished, are highly distinguished, then you can do that. Then it can identify different products. As long as there's no infringement, so you can't take the same logo, for instance, and as long as there's no consumer confusion. And the overriding policy is, if I'm in the grocery store and I'm standing, let's say that the grocery store screws up, which they do, and they put batteries next to cereal, and let's just say for, not creative right now, let's just say the battery, well, let's just call them Energizer cereal, and it's actually not a bad idea, and Energizer batteries. Okay, I get confused. What's the source? I don't know. I don't know about the quality. I don't know about the quality of the cereal. Is it Energizer battery or is it Energizer cereal? If I get confused, even though those are two different classes, then I win. Then I can shut them both out. Well, that doesn't happen very often, but that is the overriding policy. Just like a Rolling Stone. I don't think that either of these guys have thrown a fit over the other, because they've helped each other out quite a bit. But Rolling Stone magazine, Rolling Stone the musical group. Obviously, two different entities, two different groups of services. We're all very familiar. If we're not, we should be. And again, the lips. They've got a registration on those as well as the band name in and of itself. And what if more than one source uses the same mark? And again, remember, the whole idea is for your mark to identify who you are. Use your mark. That way people know what they're getting. Don't hide your mark. People want to hide their mark because they're afraid someone's going to get it. And it's not like copyright. You have to, for a trademark to be a trademark, you have to trade on it. You have to use it. Otherwise, it means nothing. For that matter, you can't register it unless you use it. So use it. Abuse it. Let people know who you are. And if someone takes it from you, sue them. It's easy. You win. As long as you've got it registered, it's easy, and you get money. So register your mark and use it. Some trademarks are also copyrights. This goes to your question. Snow White is a registered trademark. Why? Because Disney was not happy with the Sonny Bono extension. They wanted more. So this is how they're protecting all of their copyrights. Snow White identifies little girl dolls. Well, I have a couple of them, so whatever. But she does. And, Ariel identifies swimsuits. And there's a slide down here, Mickey Mouse identifies luggage. That way they get the rights into these characters, these ideas that are now copyrightable expressions. They get to keep those forever. This is a cell that from the actual film. I'm pointing to it like you all can see me point, but you can see. Okay, again, obviously, Mickey Mouse is a copyright. Mickey Mouse is a trademark for the Walt Disney Company. As long as they're in business, they don't have to worry about anybody stealing Mickey Mouse. Mickey Mouse is the most protected idea turned expression ever known to mankind. He drinks Coca-Cola, by the way. He does. No Pepsi for him. That's as corporate alliance as it gets. Mickey Mouse is a trademark for luggage, believe it or not. I mean, we're real multinational now. I used to work for the Walt Disney Company. I was in PR, and I got out before it got real bad. I really enjoyed working for them, but, I think we all know where they've gone. And I think Walt would be, he's spinning in his grave. This is a classic case where Mickey Mouse is a copyright and a trademark at the same time. So if you'll notice right up here, that's the trademark for stickers, okay? And then that image is copyrightable. They're using the same mark to sell Goofy stickers. Mickey Mouse is a trademark for stickers, guys. You can do this for your band, too, and you'll want to for merchandising. Like I said before, and I won't repeat what I said, Darth Vader is copyright. There's a poster. It's an action figure. An action figure is a sculpture. It's a copyright, okay? Darth Vader is also a trademark. Now notice there are two trademarks on this image, Lego and Star Wars. They're both pretty happy with each other also. So this way George Lucas gets to preserve all of his Death Star people for as long as he wants. I say Death Star people. I'm not a big Star Wars fan. I've grown up around it. I'm the girl who never got to play with the Star Wars action figures, so I'm like, whatever. Just leave my dolls alone, and you all can duke it out over there. Now, these are just a few good reasons to register your band's trademark. Again, it protects you against other bands using your name. This happens a lot, a whole lot. And not just within the same region, but internationally. I have a guy who's in a metal band, and he actually does the Headbangers Ball and everything. And he came into Tipitina's a few weeks ago, and there's this band in South Africa using his name, using the same name, and actually all over the U.S. too. And they stopped, but I said, well, you're going to have to go to the International Bureau, to the World Intellectual Property Organization. If any of you are interested in doing that, I'd be happy to do that for you. Now, I don't do that pro bono, but we can work something out. But he would have to go through that, get registered with the World Intellectual Property Organization through the World Trade Organization, and then go to South Africa and get registered within their country's equivalent of the USPTO also, just to get them. Now, what I did is I was pretty clever. I like to think I was pretty clever, and found out that the band's web server was located in the U.S. They're the holder of their domain name, and I got them through going through their server instead. So they had to take it off the website, which basically eliminated the value of their mark. But that's one way to do it. But again, you want to register your band's trademark if it's doing anything. You want it for merchandising so that you can license it. You want it so you can own your domain name, your website. It's negotiation leverage. Believe it or not, if you have an LLC, if you have a trademark, if you have all your ducks in a row and you're trying to work out a deal with a record label or a publisher, you look like you have your you-know-what together. And because of that, they may take you more seriously. Not always, but they may. Every little bit helps. Trust me. I've seen it. And if you don't have it together, then they're ready to exploit the hell out of you. And that happens all the time here. We all know that. Here, worse than anywhere. So if you just take these little steps to get your ducks in a row, it will help you. If nothing else, it will prevent people from targeting you for exploitation, which still happens all too often. And you want to have your rights to your own name and likeness, too. Good friend of mine, dear friend, who just passed away, and client, Eddie Bowe, there's a label in New York who's exploiting his name and likeness without his permission to sell work that they claim to own without his permission also. And his biggest beef was not even the fact that they were stealing from him, that they had stolen his masters, his publishing, and just about anything else he had left, but that they were using his photograph on their website, and he just hated them with such passion that more than getting the music back, he really wanted his name to be separated from them because these people have such a sleazy reputation. And I really want to say their names right now, and I'm not going to because they're also screwing over several of my other clients. So anyway, that's it. In conclusion, copyright and trademark are intellectual property rights protected by domestic legislation and international policies and treaties. The author and the claimant has certain rights pursuant to the Copyright Act, and the owner of the trademark has certain rights pursuant to the Lanham Act. And copyrights and trademarks should be protected. They may be, and they should be, and I can do it for you. And if you need it, that's how you get in touch with me. Now, I'll take questions. We have time?
Where's all the stuff at? Is it online?
I have packets down here, and this is on the whole workshop isn't online yet. Part of it is, but I'm going to talk to Scott about making that available online. I think Loyola may put it online also. So my information is down here. Get that, and I'll update you. If you can email me, and I'll let you know when it goes online. Part of it's online now, like I said, and then the packets are down there. But I'll make sure it gets online, and that he gets an email out to everyone about it. Yes.
Officially put this out, but mixtapes just get out.
Yeah, they do.
It eventually started getting airplay.
Mm-hmm.
He got sued for copyright infringement, but he never officially released it. So how were they able to sue him for that if it was?
Because it was registered, and this goes back to what I was talking about earlier. They got statutory damages. So if he didn't release it and didn't make any money off of it, it doesn't matter because it was registered. You can get, you know when you rent a movie and that blue screen that comes up and they try to scare you unsuccessfully? It says, don't copy, or it's up to $250,000 per act of infringement. That's true. And people are targeted. They like to target people who, especially kids who are downloading illegally with parents with, larger pockets. But that's how he was able to sue, or how the other guys were able to sue and recover. And you can get, like I said, up to $250,000 per act of infringement. So every single time that CD was handed to someone, I don't think a judge has ever said, okay, that's $250,000, but it can add up rather quickly. That's how that works. Yes?
Good question. If you don't register your mark, under the Lanham Act, can't you still sue federal court for false designation of origins? I thought that's what happened with the Californication.
Yes.
They didn't register Californication, the Chili Peppers, but yet HBO, you had that show.
Mm-hmm.
I think actually reached some type of resolution.
You can sue under a different claim, but you can't sue for trademark infringement.
Right.
It's just, for false designation. It doesn't hold up as that's an example. It's a good example, but at the same time, they had money, and they had a lot of money to defend that lawsuit, or to prosecute that lawsuit rather. And
it's easier when you're
rich, it's easy to do that, but when you're not, it's not. So, but.
Even when you're rich, you want to get your statutory damages.
Oh yeah, absolutely. No, rich people want their statutory damages too, but. Well, right, exactly, and that's why it's good to have these registrations, because that makes it a whole lot easier to win, or in that case, to make a loser. So, go ahead. Yes.
Band companies say they have some merch. They have a CD that they're selling at shows. They have a website. They have maybe a blog or a MySpace page or something.
Uh-huh.
And they want to register their marks. What classes do you think register?
Class 41 automatically. That's entertainment services. identifying you as a musical group. If you're also selling records, class 9 for phono records, and then T-shirts is class 25. I know right offhand. I mean, you can register for as many classes as you want. There's 41 classes or 44 now, but class 41 first, then class 9, then class 25. I think stickers are in a different class, but for bumper stickers, but definitely start with class 41. That's the umbrella class that'll help you out the most. Yes.
If you write music and you just write the lyrics and then you just sing it, but you don't have the instruments behind it, should you go ahead and copyright that? And
Yes. Yes, you can copyright lyrics without the music. You just copyright it as a work in the performing arts, just lyrics, yes. And if you add music to it later, then you can send in the registration as either a sound recording or sheet music, and you just have to claim the pre-existing work, the lyrics, that you've already registered. Yes.
A couple questions on trademark registration. If you register it and it's a graphic element and it's in a color,
Yes.
do you have to use it in that color to keep the trademark registration?
They like to tell you that. I mean, you don't have to use it in that color. It's because then it becomes a derivative work. But they like for you to claim color or not claim color. Unless the color makes the mark mean something, like the red Coca-Cola, then I always suggest to my clients to register the black and white version so you can use as many colors as you want. If that color, like shell, that orange, that shell orange, I'm sure they claim that the color in that mark. So it depends on whether the color is relevant to your mark or not.
Okay. And same thing about words. Let's say you have a graphic element, say like the Rolling Stones, lips and tongue, and then you add some language to it, say like Tour 2009.
Yes.
Is that still your registered mark, or once you're using
The lips
words,
are, yes.
The lips are.
Mm-hmm.
And it doesn't matter.
And the Tour 2009 isn't a mark because it says what it is. It's merely descriptive.
Descriptive, so you
Right.
can still use that and use the R along with that sort of.
Absolutely, absolutely.
Descriptive.
So I was gonna piggyback on that. So what if you have a tagline, like Nike has a swoosh, but their tagline is just do it. Do you
Uh-huh.
have to trademark that separately?
You don't have to. They have. They have. Well, they've got enough money to do that. But, yeah,
So what if you, so if it is a label and you have a graphic element, you have a tagline, could you do your mission statement as a copyright and that's a separate thing, or could you do it all as a trademark?
well, you can. She asked if you could register your mission statement first. Your mission statement would be copyrightable as a text, working text, not as a trademark.
So say with like a proposal, like if you have a concept, that would be copyrighted.
Not a concept. If it's reduced in writing, I can copyright this workshop as a literary work. If it's original.
I have another question, but after his, like, if you have like a logo and you have a font in it, if you change the font in your wording, how does that work? Like, you just do it in a general font and then you can change it. Like,
Well, fonts aren't, the font isn't going to, well, first of all, it's not copyrightable, but insofar as the trademark is concerned, I mean, does it change your trademark dramatically, or is it just, smoothing out the edges? It depends. That's a case-by-case analysis. I'd have to see it. I mean, if it doesn't change it substantially, it depends on your budget. I mean, that's a budget call at that point.
If you do a remix of a song,
Yes.
then can you copyright that, even though, I mean,
Yes.
they own the original, but can you copyright the remix part and then has?
Yes,
somebody
you can and you should, but you have to have permission
Right.
from the original author. Yes, absolutely. And it's a new arrangement. And any new material added, you just claim. And you claim the pre-existing material as well. That way everyone knows who done what, so to speak. Get him first. Go ahead.
What are the requirements a band needs to meet to take the benefit of the program?
There's an application through the Arts Council and through Tipitinas. It's like 4 questions. They ask you what your income is, and I think it's less than 30 grand, so I don't think very many bands are making that these days. And you have to be either a member of the Arts Council or the co-op, and the co-op I think is $10 a year, and they'll waive it if you need it. So that's about it. Real stringent. Go ahead.
I just had a question about copyrighting songs as opposed to Like if you have an album with say 10 songs on it, should you register copyright each song individually, or is it okay or substantial to copyright the whole album with 10 songs on it?
You can register the whole album on one copyright form, if you did all the work on it. Now, if you're a songwriter and someone else records it, you'll want to register those songs independently of the sound recording. That depends on that unique combination of authorship deal. If it's all the same people doing all the same work on all the songs, put it all in one form. Saves you money. But if not, then you either have to give credit to someone who didn't do the work, or you pay the extra $35. The extra $35 will save you a friendship, maybe your marriage, business, all kinds of things in the future.